All right, so here we go. Thank you, everybody, for joining us tonight for a very special candidate forum in this 2022 election cycle. Secular AZ is a 501c3 organization focused on protecting the Constitution and the separation of church and state in Arizona for over a decade. This year, we've focused a lot on school board races, and we do have one more school board candidate forum with the candidates for Catalina Foothills coming later this month. But in the lead up to ballots dropping on November 12th, we've decided to have candidate forums for our larger races, including this special election for Maricopa County Attorney, as well as several of the statewide races. You can see that up on the screen. Thank you, Lindsay, for putting that up. And tonight I'm excited that we are hosting this forum for the special election for Maricopa County Attorney. Both candidates were invited to this forum, and the Democratic nominee, Julie Gunnigal, is here with us tonight. Someone from the Rachel Mitchell team responded to our email yesterday to say, and I quote, "Unfortunately, Ms. Mitchell has a scheduling conflict on the evening of September 7th and will not be available to participate in your event." They go on to say, "Scheduling conflict aside, given your longtime public support and endorsement of Ms. Gunnigal for county attorney, I don't imagine this will be an objective forum. I would like to point out that Secular AZ does not endorse candidates, but we do provide all candidates an opportunity to share their vision for their respective offices. We ask each candidate the same questions. We give them equal time to answer and respond to their opponent when the opponents show up. We also open it up to viewers so the taxpayers and voters in the audience may ask questions of candidates. So please, if you do have questions tonight, you can go ahead and submit them in the Q&A or on Facebook. Now, I want to point out that Ms. Gunnigal today does have another engagement, so we're lucky to have her. We'll be ending probably around 7:10 at the latest. So objectively, our viewers care very much about how their elected officials will uphold their oath to the Constitution and how they will preserve the separation of church and state while leading with their values and being good stewards of taxpayer dollars. If you enjoy these candidate forums or our many other virtual speaker webinars and events, please consider becoming a member, volunteer, and or donor at secularaz.org today. And now it is my pleasure to introduce the candidate who did show up tonight to talk to the voters about their race and how they will uphold their constitutional oath of office. And now I really condensed this because this would have taken a half an hour just to share her bio. You can go to, I think it's Gunnigal 2022, right? Gunnigal2022.com if you want to read the full thing. But Julie Gunnigal, she's born and raised here in Arizona. Her mom was a teacher. She is a product of our public schools. She attended NAU, received her law degree from Notre Dame Law School, served as assistant state's attorney in Cook County, taught as a law professor, is a mother and wife, marathon runner, and dog mother to Potato. Welcome, Julie Gunnigal. And did I miss anything in your bio that you'd like to add?
No, skip the children. Make sure we talk about the dog.
I won't tell them that you said that. All right. So without any further ado, again, like I said, we do have the Q&A open. But first, let's just clarify. Could you give us a brief description of the role and responsibilities of the county attorney for those who maybe don't know what y'all do?
With pleasure. For those who don't know what the county attorney does, first, you're not alone. This is one of the most important positions in a down ballot race with national implications. But most folks don't know what their county attorney does. In the simplest terms, this is your DA's office. This is your prosecutor's office. This is your state's attorney's office. We call it the Maricopa County Attorney's Office here. It has the responsibility of prosecuting all of the felonies that occur throughout our county and all the misdemeanors in our unincorporated areas. It's also the chief legal advisor to the multitude of county agencies. So it has an enormous civil role, and that translates directly into upholding our elections as well. But this is actually the third largest prosecutor's office in the entire country. So I think that's really important to underscore, because when we look at the history of this office, instead of leading the nation when it comes to all things criminal legal system, we've been followers. And I think that's one of the legacies that we can end if we get a reform-minded county attorney.
I just wanted to have my script right there with me. So yeah, so, let's go ahead and kind of talk a little bit about that. So, and thanks to Diane Post, who is our head of legal, also one of our board members. She came up with some great questions to kind of help me out a little bit. Much more thoughtful from her, legal perspective than probably my layperson's understanding. So Diane asked, how would you go about changing the culture of the office that has been shrouded in scandal for so long? Great question.
Sure. I mean, let's just briefly talk about what that scandal looks like, because I think addressing the root cause of the issues in the office is how we can actually build a culture that's productive going forward. So this has been an office that has been historically corrupt. Our new voters, our 18-year-olds who are just registering now, have not seen a county attorney's office that wasn't under the shadow of scandal during their lifetimes. And whether it be Andrew Thomas, who was engaged in political prosecutions and ended up being disbarred, or Bill Montgomery, who allowed sexual harassers to roam freely throughout the office, or whether it's our previous county attorney who allowed her chief of staff to wear blackface and not face discipline, who forgot to file 180 cases, or engaged in the historic corruption of charging protesters as gang members, one of whom was facing up to 100.5 years for nothing more than raising their voice in defense of Black lives. This has been a historically corrupt office. So I think there's a few different ways that you get around that. First, this office has hiring issues and can't even file basic DUI cases right now because it is so understaffed. And that is a direct result of the culture. New attorneys don't want to join an office where they risk facing a bar complaint, or where the first question on their next interview will be, you worked for that office during that time? So we have the opportunity to bring in new attorneys who are more justice and reform minded to help change the culture. Also, we need to acknowledge that there are so many attorneys who've been there for 20 or 30 years who carry with them this idea that they are in fact above the law, that they don't need to play by the rules, and that when it comes to instances of prosecutorial misconduct, that their conduct will be excused by the office because that has been the history and the tradition. So that changes when we have new leadership who brings to it fresh ideas, who brings to it the real determination to make sure the line attorneys are empowered to do justice, not just seek convictions. And then most importantly, putting the idea of what is truly in the public interest and public safety and our taxpayer dollars first. And if we were able to just change those things, I think we'd see a huge benefit overnight, and we would see this office finally be able to start earning the trust of the community.
And so that takes me to another question that I think the answer is really obvious here, but will your measurement of success be a high conviction rate?
No. So here's the thing, and I think this is a fundamental difference in perspective, myself versus my opponent. Because recently my opponent has been making claims about just how tough and strong she is. And that means putting people into prison for incredibly long sentences after harm has occurred to the community. Where I think your county attorney is absolutely failing by every objective measure is being forward thinking enough to know what we need to do to prevent harm in the community. And when we start engaging in that sort of root cause analysis, we start seeing prosecutors who aren't merely seeking convictions, they're actually seeking justice. And that looks a whole bunch of different ways, by the way. I mean, that looks like big investments into alternative courts, things like veterans treatment courts on a felony level, which we know work. It looks like having diversion programs that work, that actually treat gun violence, mental health, and addiction as the public health crises they are, instead of an excuse just to incarcerate someone. And then it looks like being proactive in creating deflection programs, because there's so many of these low-level offenses that enter our criminal legal system at great expense to the taxpayers, where what that person really needs is connection to service providers. And if a county attorney was forward-looking, and this is what we've seen in other jurisdictions, not only does it keep the community safe by getting at the root cause of harm, it actually ends up saving you a heck of a lot of money on the other side as well.
So in order to, kind of shift the culture, What kind of training would you initiate to newcomers and to experienced deputies to make that change happen?
Sure. I mean, I think that part of that culture change needs to acknowledge who has been historically left behind and criminalized by the system that we have now. And to speak very frankly about race, our Maricopa County Attorney's Office has perpetuated some of the biggest racial disparities in policing and prosecution in the nation. Right now, about 19,000 people will go to bed tonight in an Arizona prison that were sent there by the county attorney's office. And about 20% of those folks are Black, despite the fact that in our community, only about 5% of our population is almost 400% overrepresentation. And it really behooves us as attorneys to be thoughtful in addressing historic injustices, so that we can move forward as an entire community. It is equally true that Latino folks in our community on average pay $400 more in fines, fees, and court costs, and that we continue to see racially disparate stops. The spirit of Joe Arpaio is still alive and well over in the county attorney's office. So I think there needs to be some unlearning of these practices. There needs to be an intentional audit of the kinds of cases that enter our criminal legal system. The gold standard for such an audit comes from the Vera Institute for Justice, which is an intentional way of looking at, these are all the folks that came in. This is the plea bargains that were offered. Are we equally serving the community? And from there, being able to make intentional policy decisions. So what that actually looks like on the ground in terms of training and practice is that in one instance that used this model, they found that the reason why people of color who were moving through the criminal legal system were facing higher fines, fees, and longer sentences of incarceration was that every time a person of color entered on a drug charge, they were not only charged with possession, but also a paraphernalia offense. And the prosecutor's office was able then to make the determination, okay, this is where the injustice is happening. Here's what we're going to do policy-wise to move forward. Equally so, you find this with serving victims, that when your victim is a person of color and the alleged perpetrator is, for example, white, you oftentimes see that those crimes are charged less frequently by the attorneys, or in the alternative, that they aren't even pursued at all. So the way I envision this office is that we are intentional when it comes to the historic inequities, that we train our attorneys accordingly, that we support our attorneys. Did you know that we still are asking our attorneys to come largely back to work in person, despite the fact that we know that remote court works, especially for parents who are still going through this cycle of COVID hitting their households and their kids in school, and they have elders that they're caring for. We could support these attorneys a heck of a lot more in the workplace. We could also be more supportive when it comes to our mental health care of those who serve others. Because listen, as a prosecutor, gosh, this is vulnerable. You see some horrific things, and you can take on those sorts of thoughts and images to this day. And when I'm talking to prosecutors, especially prosecutors who are handling issues of family violence, what we hear is that they are not supported. They try to be as strong and as powerful as they possibly can be. But when you see those kinds of acts day in and day out, there's more self-care that needs to be done. There's more therapy that needs to be provided. There needs more support in the workplace that needs to happen. So when it comes to personnel, those are my thoughts and vision is how we're going to build this out and finally be able to recruit people to this office that right now can barely function as a prosecutor's office.
Great. Evelyn is in our webinar audience right now, and I'm going to go ahead and follow up with her question. She says, that is a great point. Arizona has been known to be very biased with prosecution of crimes. Many Black and Hispanic crimes remain unresolved or uninvestigated. Do you have a plan to change this and get those cases back on our investigators' hands and dockets?
Yes, absolutely. And again, it's through this intentional reflective process. We need to know where those reports are being taken. And sometimes these reports aren't even taken at all. One of the things that we can do to remedy that, and one of the proposals that I have, is a conviction integrity unit that takes a second look at either cases that aren't charged, cases that are charged for the wrong reasons, cases that end up in where the person is either actually innocent or there's claims of prosecutorial misconduct. There needs to be a mechanism in the system that gets at that issue. And those offices that have been most effective have done it through a conviction integrity unit that is both forward facing, that is transparent, and that is community involved.
Great, thank you. You know, and you did bring up nonviolent drug offenses somewhere in the answer there. And you know, I would like for you to kind of talk about, because give some background about the, you know, expungement of these nonviolent marijuana cases, and even if you want to, the work that you've done over the last 2 years in helping to expunge those, and the role that the county attorney's offices play in that process. You know, I just assumed, and again, you'll have to remind me when you answer the question, that with the passage of that law, that it would be automatic, that everybody who had ever had a nonviolent marijuana offense would be able to, you know, just get it off their record automatically. So could you explain that to people?
Sure. I think a lot of voters thought that too. So when the Arizona voters passed Proposition 207 that gave us responsible adult use, it contained a provision that said that every single county attorney, all 15 of them, plus the AG, could initiate expungement processes through their office. Now, we have no idea, just to put this perfectly frankly, we have no idea how many people in Arizona have been criminalized as a result of marijuana. And that's because the way that we kept data for such a long time, either through DPS or through the court records. But our rough guesstimate is that somewhere between 250,000 and 500,000 people still have a conviction, an arrest, or an adjudication for a low-level marijuana offense. That is possession under 2.5 ounces or 12 grams of concentrate, low-level cultivation offenses, fewer than 6 plants, or paraphernalia offenses. So when it became clear that the county attorney, and actually all 15 county attorneys and the AG's office had zero intention of doing these expungements and making it so that people could have this real second chance universally and automatically, I became involved with Arizona Normal. I spent my summer learning how to code, and we went to every county in Arizona and did over 60 plus different expungement clinics, trying to give people that real second chance. To this day, it's over 2,000 expungements that we have handled. Yeah, it's huge, but it comes nowhere close to the power that the institution could have in purging these convictions. And the thing that I would really want people to know about that is that expungements are crime prevention. Expungements are a prevention and a hedge against becoming unsheltered in Arizona. One of the places where we expunge the most convictions were either out in the zone or at these resource fairs for people who are experiencing homelessness. And one of the things that they said again and again is that they want housing. They are able to afford housing by virtue of their jobs. But because Arizona continued to have cannabis up until November of 2020 labeled as a Class 6 felony drug arrest, that when they go to have their credit checked or their criminal background checked for these homes, that they don't qualify to rent. So one of the things that I learned from all of this is that cannabis is not a gateway drug. It is for sure a gateway conviction that almost ensures that people will have future entanglements with the criminal legal system. But what we need to do in this office transcends marijuana policy. It transcends being able to universally and automatically expunge these convictions. It also means that we need to get away from these long sentences for simple sales, which are continued to this day to be illegal. And we just recently saw the county attorney double down on a 16-year sentence for a 21-year-old who had sold an ounce of weed, a substance that is now perfectly legal. And when we look at what that taxpayer cost really is, especially in light of the fact that this is now legal and the state at most missed out on a couple bucks worth of tax revenue, we collectively are going to spend $330,000 jailing this person, imprisoning them during the most productive years of their life, and making sure that they can't hold a good paying job, parent, etc. And for what? So as we're looking at the system, one of the things that you'll see, and I'm sure that we'll get into tonight, is a real commitment to doubling and tripling down, not on these incredibly long sentences, but on treatment. Because that's not what's happening right now in the system. What's happening in the system right now are folks like Michael Calhoun, who's one of the ACLU plaintiffs against the office. And I know I've told you this story before, Jeannie, so please bear with me for those out there in Zoom land. Michael is somebody who, if you asked him, would tell you that he is addicted. His rap sheet says the same thing. It's a bunch of low level, mostly possession cases. And when he was caught selling $20 worth of drugs, the county attorney's office said that his best and final offer would be 9.5 years. 9.5 years where he's not parenting, 9.5 years where he is not receiving addiction treatment. There is no amount of incarceration. We cannot incarcerate the addiction out of a person. And the thing about it is 97% of everyone behind bars right now will one day get out. And if we are not using the system to better equip them to rejoin society, to re-enter, to have a job, to access treatment, to access mental health care, all we are doing is perpetuating the same costly cycle of incarceration that gets a select few Arizonans rich and that the rest of us have to pay for.
You know, and as a lifelong educator, that is the first thing that I think of is, you know, for this individual who is now caught up in the system. I have seen firsthand the aftermath of not just the family and the extended family, but of the entire community, of the entire neighborhood. You know, the cruelty sometimes seems to be the point with some of these things that take place in our district attorney offices. And unfortunately, not often enough do they think about the societal outcomes and impacts that this has. So there is another question. There's actually two now. This one comes from Evelyn again. Evelyn says there are many news reports and articles showing complaints against officers and how those involved retire or change positions to avoid being Brady listed. Is this something your office will investigate or have a special task force, an efficient one that closes these loopholes? Great question, Evelyn.
Yeah, that is a beautiful question, Evelyn, especially because here in our county, until about 2 years ago, we didn't even have a functional forward-facing Brady list. ABC 15 had to do that for us because of this exact problem, officers going from force to force to force, and their records not following them or not being disclosed to defendants. So when we talk about Brady materials, just for those who aren't in the know, what that means is that when someone is accused of a crime, they're entitled to all the exculpatory, that means like exonerating evidence against them. And one of the pieces that they are entitled to is any of the documentation that an officer who investigated has a history of misconduct, whether that be sometimes it's violence, sometimes it's lack of truthfulness and candor, etc. And in those instances, we need to have a functional Brady list. One of the things your county attorney can do is make sure that the Brady list is up to date. We know for a fact that that is not the case because we know that those officers from the protest cases to this day are not on the Brady list. Some of the other things that your county attorney can do to ensure that everybody is held to the same standards of law, because it is still very much the case that the wealthy, the powerful, the well-connected, and the police play by different rules than the rest of us, is they can have an independent unit for police use of force cases. That means you'll never have to wonder whether or not a prosecutor evaluating one of these cases has a conflict of interest, because prosecutors are asked day in and day out to work with law enforcement to prove up their cases. So to ask those same prosecutors to turn around and hold officers accountable when there's an allegation is an incredibly difficult task. And that's why we need something that is truly independent, that still answers to the county attorney, but is not involved with all of these line cases. The last thing that I believe that we need to have a no-call list, because there are instances in Arizona where an officer's misconduct rises to the level that not just it needs to be disclosed to the defense, but that it rises to the level that they should never be called to testify from the county attorney's office. And that is one way to get at this instance that you raise of somebody going from municipality to municipality, and that's a record that the county attorney can and should be keeping.
Great, thank you for that. This one comes from Ed. and I hope I pronounced well, Ed Birchinall. I'm going to hope that that's the correct pronunciation. He says, related to the expungement issue, what role does the county attorney's office have in restoring voting rights to those who have had those rights taken away? Great question.
Oh, good question. Glad you asked. Yes. So the county, not necessarily the county attorney, but the county does regular clinics to help restore voting rights. And for those who are eligible to restore voting rights, I highly encourage you to use this particular service because it is not easy to restore your voting rights in our county after somebody has been disenfranchised because of a felony conviction. Loosely stated, here's the way it works. A single felony conviction and after the close of probation or an absolute discharge from the Department of Corrections, voting rights are restored automatically. And that also includes several of the civil rights, not necessarily including gun rights. But for anybody who had either 2 felony counts in the same case or multiple felony cases, you have to go through this process. And the process takes, well, I have a case that's still pending and it's 9 months out at this point in time, even without objection. But it's really important to have a good attorney. And ideally, if you can go through the government clinic, a government attorney who can access an entire criminal record, because you can see how easy it is to get wrong and how easy it would be for someone to, for example, forget where a different case occurred, for example, and then they think their rights are restored, they register to vote, and registering to vote when your rights have not yet been restored is also a felony. So there's so many traps for the unwary in this process. So I think there is a role for the county attorney, to give grace in those cases where someone has made a good faith attempt to restore their voting rights, to be proactive when somebody has filed a petition and place that notice of non-objection promptly into the record to help speed them along. And then the last thing I'll flag for you too is I believe in expungements. Expungements are powerful things, especially when it criminalized a plant that should have never been criminalized. But that was also the only instance of a real second chance we had under Arizona law, because for everybody else, all we have is this idea of a set aside, and those don't occur in almost any other jurisdiction. Nobody knows what they mean. They don't actually seal records. But on January 1st of this coming year, record sealing goes online from SB 1294, and that's going to open expungement up for a whole range of other offenses. There are obvious exclusions like instances of sexual assault or misconduct with a child or murder, etc. But when enough time has passed, this is our first attempt at actually helping people in an over-incarcerated state get a second chance. And I believe that that's going to be powerful for crime prevention as well, because we know access to opportunity is at the root cause of so much harm in our community. And you'll have so much more opportunity if you're able to get a real second chance.
Right.
Forgive my soapbox. I know I went on way too long on that one. This is just so important.
I don't think that our members are going to be upset about that. So thank you. This one comes from Sarah Mickelson. And Sarah says, hi there, Julie. What's your position on prosecuting doctors and patients for providing or seeking abortion care? What are some of the types of cases you expect to see, and how will you handle those?
Ooh, all right. First question of the 3 is the easiest because it was the first question I was asked when I jumped into this race. And the answer is not now, not ever. I will not use the power of the criminal legal system to criminalize doctors and patients. Full stop. How we get to that result, I think, is a little bit trickier. So everybody should know that this office is empowered with prosecutorial discretion. That means it's only able to bring cases that are in the interests of justice. That encompasses whether or not a statute is constitutional, whether or not there's a likelihood of getting a conviction, what the investigative process needs to look like, and whether it's a good use of taxpayer resources. And prosecuting abortion is none of those things. What I expect to see is I do think that there will be doctors who come under the crosshairs of the county attorney's office, especially before the election, and especially because this has been so politicized. We're already seeing anecdotal evidence that some doctors who are so worried about criminal prosecution under our 1864 abortion law are holding off on some abortion procedures, particularly for ectopic pregnancies, because they are so afraid of what the law says. There's a couple different laws at play. The 1864 law is a mandatory minimum of 2 years in prison and a max of 5 for anyone who performs an abortion. It does not have an exemption for someone who self-performs an abortion, and I find that to be incredibly troubling. It also carries with it a little sister law, which is a misdemeanor offense for the advertisement of abortion and contraceptives. And our county attorney and General Brnovich have said that these laws are applicable right now in Maricopa County. That's not even the worst part. Then we get to on September 23rd, the 15-week ban will go into effect. Now, there aren't criminal penalties that I'm aware of in the 15-week ban, but that for sure will place licensure penalties on anyone performing a procedure past 15 weeks. And again, it does have that idea of a good faith exception for health and safety of the mother, but not one for rape or incest. And doctors are incredibly concerned about what good faith means in an environment that is politicized as this one. The third law, and this is the one that is actually that weighs on my heart as I am raising, 2 daughters who are coming up on reproductive age, is our fetal personhood law. 2 legislative sessions ago, the legislature passed and Doug Ducey signed SB 1457, and that was a law that said a fertilized egg at any stage of gestation has the same rights, privileges, and immunities as you or I, meaning that anytime it says person in Arizona law, it also means a fertilized egg, setting up the very real possibility that someone could be guilty of murder, even first-degree murder, or criminal child neglect for accessing an abortion, or get this, driving someone to an abortion could be, acting as an accessory to abortion. Someone who pays for an abortion, someone who agrees to commit an abortion, the other medical providers in the room, whether or not they are actually performing an abortion. That law is currently enjoined, thank goodness, but we do not know for how long at the federal level. So what is this actually going to look like? I think there's a couple of well-informed guesses that we can make. There may be doctors who find themselves in these crosshairs. But let's be real, Maricopa continues to perpetuate a 2-tiered system of justice. We know that especially Black Arizonans, Indigenous Arizonans, Arizonans of color, Arizonans with disabilities, LGBTQ Arizonans are more likely to face the harm that comes from the enforcement of these laws. We also know that even when Roe was in effect, there were 1,700 documented cases where the criminalization of pregnancy occurred. And so what those look like are cases like Christine Taylor from Iowa. She was a mom. She was heavily pregnant. She fell down the stairs. She told, when she reported to the emergency room, she told the nurse that her marriage was on the rocks, and she didn't know how she was going to parent the child that she was carrying, but she also didn't know how she was going to be a solo parent to the 2 other children at home. And the nurse turned her in for a suspected abortion, and she served 2 nights in jail for attempted feticide because of these sorts of laws and their interpretation. I mean, it's not a far cry from Marsha Jones, who was a woman in Alabama who got into what started as a verbal altercation in a parking lot. She was pregnant. She was shot in the abdomen by someone else, and she was criminally charged for failure to protect her fetus. Or what we're seeing in Alabama right now, where we're seeing people who are being jailed so that it is in protection of the fetus that they are carrying. That's what we're likely to see. And we know who it's most likely to be waged against. It also, I think, is really important to flag for you that these investigations and these cases don't prove themselves. So think for a second of what you conceive of as a crime scene if the crime is abortion. And it is quite literally a person's body. And what we are truly proposing when we are going down this route of enforcing this either 1864 abortion law or this new Doug Ducey abortion law is we are proposing making people's bodies a crime scene, where a pelvic exam would be what would be required to prove up this case. And for most of us living in Maricopa County, the vast majority of the population is inside the jurisdiction of Phoenix PD, which to this day is one of the most violent police forces in the country, but would be the force that would be empowered to perform these investigations. Like, that is the hellscape that awaits us if we have a county attorney who's willing to dabble in abortion politics. I'm sorry, I'll get off the soapbox now, but that's what it looks like. That's why it's so scary.
And then, I think about too, the fact that there are, in most of these states now that have these abortion bans, there aren't, not a lot of them have exemptions. And so I also, for rape or incest, and I think about, somebody who's already been traumatized with sexual assault, and then like the re-traumatization of those individuals who have already, gone through so much. It's just, again, sometimes in this day and age, the cruelty seems to be the point.
Well, may I
yeah.
build off that for 1 second too?
Yeah.
Because the issue of rape or incest always gets me in the heart, because I've seen those sorts of cases. I've held the hand of someone who has gone through an abortion after an event like that. It's really, really hard. But first, we should be protecting these rights no matter what, because your body does not need to be violated before you should have the right to control it. But in those instances of rape or incest, we also shouldn't be relying on someone who says that they're going to maybe exercise prosecutorial discretion. And the reason why is that in Arizona, we do not prosecute rape or incest. In the city of Phoenix right now, our sexual assault clearance rate is below 9%. Which means that in fewer than 9% of the cases where someone actually reports, which we know is the small minority of actual sexual assaults that occur, in fewer than 9% of those cases, is there ever an arrest? And in fewer than 2% of those cases, is there ever a conviction? And we went through an entire 5-year span where my opponent was the head of the sexual assault bureau, where there was not a single charged sexual assault on ASU's campus. Just total non-prosecution policy on one of the largest campuses of one of the biggest universities in the world, where there's a well-documented problem. So I take issue with the idea of first making it only available for victims of rape or incest, but also thinking that would even be an excuse in Arizona because it goes unprosecuted, leading to the very real result that in 2022 Arizona, if we do not get this election right, a person who is sexually assaulted, who becomes pregnant, is more likely to face prosecution for having an abortion than her assailant would be for assaulting her.
Wow. That really puts it in some, I don't know, dystopian terms for everybody to kind of understand. This next one is coming from the audience, from Beth Hauk, who is also part of our legal committee. And we answered part of it. Will you prosecute abortion cases? Not now, not ever. Do you think, and let me make sure I get this right. Do you think the Arizona constitutional right to privacy protections to right to abortion as a medical decision? The grammar's a little off there, but I think it's about the fact that in the Arizona Constitution, there is a provision there about privacy protection. So I guess the question from Beth is about, will that apply to abortion as a medical decision?
Oh, and I've really struggled with this, and I've come to, I think, a different conclusion than several other attorneys who have looked at it. So yes, our Arizona Constitution is unique in that it contains a specific right to privacy, which is the thing that the US Constitution never did. It was always implied, eventually comes out of the 14th Amendment. Nevertheless, there have been bold litigants who have tried this exact argument before. In fact, one litigant who I especially love and respect, Stanley Feldman, brought this claim in 1971 in Arizona court, saying that the right to abortion is constitutionally protected as part of this right to privacy. And Arizona courts shut that argument down. It was only because Roe v. Wade occurred in 1973 that case eventually was won. That's the injunction that we talk about when we talk about the 1864 abortion law. So I would love it if the Supreme Court looked at the at privacy that way. I would love it to see, the court starting to share our values and interpret what privacy really means as we talk about it as a community. But do I think that constitutional amendment is going to, or that Constitution, it's not even an amendment in ours, it is our Constitution coming to save us? I am not convinced given previous precedent. I think we get there instead through prosecutorial discretion and electing people who share our values.
Okay. Thank you. And this is the last one in the Q&A for now. And if you'd like to add a question, by all means, go right ahead. This one comes from anonymous attendee. They would like to know how many sexual assault cases you have actually tried before a jury.
Sure. So my sexual assault caseload was in juvenile court. I was actually the juvenile bureau chief in Elkhart County, where I handled child-on-child sexual assault cases throughout actually my entire career there. So I don't know. Those cases don't go to juries because they go instead to a bench trial to protect the juvenile. But how many did I handle? I don't know, well over 24. Some of which still keep me up at night. I'm glad I did it. I'm glad I handled those cases before I became a parent. I can't imagine handling those cases now. And I have the utmost respect for prosecutors who are able to go into those courtrooms and hold people accountable on the most ghastly set of facts that sometimes people can imagine.
Yeah, that's got to be a tough job. I remember working with an officer who was a SRO at one of the schools where I taught, and he had come out of the child crimes unit, and he was telling me how that, the tenure for that is a very, very short amount of time, because, the stories that you hear are really brutal. So I can't even imagine.
Well, yeah. And I mean, I think there's still room for rationality when it comes to sex crime laws. I think the other thing that we need to acknowledge as well is that the under prosecution and under involvement is at times intentional. Just like violence, it's very rare for someone's first encounter with violence to be committing it. And the same is true oftentimes of especially child-on-child sexual offenses. So it is gruesome stuff that oftentimes leads from case and investigation, a conviction, and another case coming out of the exact same family. And those are fact patterns that keep me up at night. It's why we need to pour resources into the crimes that matter most, crimes that target women, children, and our seniors, crimes of violence, and crimes against democracy.
Okay, so let me go back to some of the questions that we have over here. And this is a good question, because, show me the money, show me your budget, and, you'll show me what you value. So this question is, what kind of budgetary changes have you considered for the Office of Maricopa County Attorney?
Sure. I think we need to have more information than what the drill down is on what's the published budget that comes out of the Maricopa County Board of Supervisors for this office. The budget, speaking generally, is about $101 million. There's oftentimes additional federal grants that are issued and available. My biggest priorities are making sure that victim services is fully staffed and that is actually responsive. One of the biggest things I've been hearing on the campaign trail is that even when cases are pursued, the communication from this office is so incredibly poor. And we have a real opportunity to step up the way that communication looks and works. Given my priorities, and my priorities are driven by what the community has been talking about for the last decade of changes that we need to see in this office, I would like to see more resources poured into violent crimes and crimes that target women, children, our seniors. That also means that we are training prosecutors on those sorts of issues and how to handle our more sensitive cases. It also means the prioritization of some of our low-level drug offenses, with the idea that diversion programs that work, specialty court programs that provide wraparound help and assistance, and instances where someone can be deflected from the criminal legal system are absolutely the way to go, such that we can spend the time and attention on this other set of cases that, frankly, the community is screaming for us to be able to pursue responsibly.
And I'm going to try to pick and choose some of these other questions, partially based on what my own interests are, but also to kind of honor what other people might be wanting me to ask you. But they're all really, really good questions. Let's see. I like this question because I know quite a few people who have acted as public defenders, and I know about the pressure about plea bargains. So this one, lawsuits have been filed around the country about overcharging and overuse of plea bargains by prosecutors. What plans do you have to deal with these issues?
Wow. When you get at that issue, you get at the heart of some of the issues inside the criminal legal system, because what we've seen over the last 200 years is the evolution of a system where a judge has the majority of the power versus a prosecutor having the majority of the power. The way it works right now is that when cases start in the criminal legal system and there are charging decisions that are made, those charging decisions, which are made incredibly early in the process and oftentimes incredibly early, even in the investigation, are outcome determinative. And what I mean by that is that when somebody is held without bail or bond, they are far, far more likely to plead. When someone is given a Donald advisement, they're told that if they do not take this plea, the next plea will be substantially harsher. They are far, far more likely to plead. When they're put through an early disposition court process, they're far, far more likely to plead guilty. And this includes crimes that they might not have even committed, or where they weren't given the opportunity for intentional reflection. One of the things that we're often hearing from defense attorneys is that this process, which is incredibly abbreviated, they have to advise folks as to whether or not to accept a plea without seeing the entire investigation and all of the evidence, without seeing body cam footage, for example, or without seeing lab reports. It's one of the reasons why the ACLU sued the county attorney's office round about a year and a half ago. But we are also seeing the demise of these sorts of courts entirely on their own. At last report, they're having trouble even finding contract attorneys to staff these courts because nobody wants to be doing a haphazard job of defending their clients. And this is what the conveyor belt of justice looks like in our county. Now, that being said, I think there are responsible ways to scale back reliance on these sorts of early disposition courts. They were originally designed for low-level drug cases so they can move quickly through the system, out of the system, and into treatment. Instead, they have been turned into plea bargain factories. And once we start relying on treatment as a best option, once we start relying on specialty courts where appropriate, and once we start deflecting some of these cases that shouldn't even be in the system, we're going to see a lot lesser reliance on these sorts of courts that move people to what I believe is either a 97 or a 98% plea bargain rate in our county, which may seem incredibly high, but is not, it is pretty on pace with American justice right now.
Okay, so we have, I would say, about 12 minutes left. So I really like this question though, because I think it's a great question. Do you have any plans to partner with ASU Law School or existing legal groups such as Women's Lawyers Association, Los Abogados, Black, Asian, gay lawyer groups for education or outreach to ensure diversity in the office?
Oh, I love this question too, because right now the attorney leadership side is entirely white, and that is absolutely unacceptable. It is my goal as your next county attorney to make sure that the leadership and the staff reflects, well, actually is as diverse as the community that it seeks to serve. So yeah, I've actually been making intentional outreach efforts right now at ASU and U of A, just to talk actually to these law students who want to become prosecutors and find out why it is that they are not applying to become Maricopa County attorneys. What is the disconnect there? So yes, we need to engage not just our new attorneys who are entering the profession. We need to engage these specialty bars because they are the subject matter experts and there's so much talent there. And then we need to be engaging with our HBCUs where we can recruit for so many of the positions that are open in this office. And then last, we need to be engaging with the actual community. I cannot tell you how many attorneys I have talked to in the last 3 years who began their career at the county attorney's office, but left because of the leadership of Andrew Thomas, Bill Montgomery, or others. There's so much talent out there who wants to end their career at the county attorney's office and wants to rejoin this effort to make Maricopa County more just. And the staffing issues there can be solved by effective leadership that is a true homecoming for those who are justice-minded and want to get back into the office.
Yeah. Yeah, I know a lot of those attorneys actually who, kind of sailed in and out of that office, and for the, for the very reasons and the leadership that has existed ever since I can remember. Let's see. I like this question a lot. Let's see, where is it? Where is it? What lawsuits? Lawsuits have also been filed around the country, and rule changes here in Arizona about bail and the fact that it's often unfairly imposed and an unfair punishment of the poor. What is your position on bail in the prosecutor's office? Great question.
Yes, I mean, by and large, I agree. The question then becomes, what do we do about it? So to lay out the problem, when it comes to, in particular, cash bail and bond, that's what we're talking about. The person who wrote this is absolutely right. It is far more likely that you are going to see higher cash bond on folks who are the least able to pay it and have been the most historically discriminated against in our criminal legal system. It has led the NAACP to help lead the charge to eliminate cash bail and bond in Arizona. Now, our bail bond system is in part discretionary and in part legislative. So one of the things that I believe is that when we're looking at this system, that you cannot look at somebody's wallet or bank account and determine how dangerous they are and how likely they are to return to court. And that's just the truth. Those areas of the country that have eliminated cash bail and bond still see the same number of defendants returning to their court date and don't see an uptick in violence. If anything, they actually see dips because somebody who is out on bond is able to keep their job, is able to keep their housing, is able to keep their kids. So I think it's an incredibly important issue that the county attorney needs to work with the bar, and there's actually been an extensive report put out by the Arizona judiciary who studied the way that we use cash as a surrogate for whether or not someone will return or whether or not they're dangerous. And then the legislative process in Arizona, because that you can't, if you're looking to fully eliminate it, it has to go through the legislature, and that's just the truth. For those who say that that sounds, out of line, we've seen multiple jurisdictions who've been able to do this, and what they've seen is increased community safety and the same number of people returning to court. It blows people's mind when I tell them that the largest criminal legal system to abolish cash bail is our federal system, and it did it in the 80s and replaced the idea of cash with the idea of conditions of release that look at the dangerousness of the person, look at their likeliness to recidivate while out, and have been effective in mitigating harm while still preserving the presumption of innocence. So this is a really well thought out, incredibly well researched idea, and it needs to get some legs. It needs to get some traction at the Arizona legislature, and then we need to demystify it, because I can tell you, especially in my race, this is the attack ad that I somehow am not committed to wealth-based detention anymore, and it's true. I'm not committed to wealth-based detention. I think we should gauge whether or not someone is detained based on their dangerousness and their likelihood to return to court. And the Constitution says that too, by the way.
Yeah. We like the Constitution here at Secular AZ, in case you haven't figured that out. So I'm sure a lot of our viewers are probably on board with that. And this question kind of goes right in with that. So how would you work with the state legislature if it retains its Republican majority?
Sure. So first, let's talk about how this office has worked with the legislature in the past, because this office has been one of the reasons why reform efforts get stymied nearly every single legislative session. Good ideas emerge at the legislature, evidence-based ideas emerge, even in a caucus that we might not share values with or agree with. And then the county attorney comes in and says, no, you can't do that for X, Y, Z reason. And this happens not just on bills involving the criminal legal system. The greatest example I can remember is, what was it? It was Hannah Pryor's, the idea that you can charge someone as a repeat offender the very first time that they're arrested. But we also see that in other county attorneys' tenure on issues that were wholly unrelated to the criminal legal system. For example, Bill Montgomery stopping the effort to extend the statute of limitations for childhood victims of sexual assault through the civil process. So First, this bully pulpit has been used for the to enhance the criminal legal system, to make it larger than it is, to create a growth in government over the last 3 decades. What can we do? Well, I intend to use this office and work with the legislature to create reform efforts that are data driven, that are evidence based, and that are rooted in actual real public safety. And I think that is actually, apart from the core mission of this office and restoring its integrity, one of the greatest things that we can do for Arizona.
Great. And I think I'm going to make this the last question. And then because I want you to wrap it up, please post or announce where we can pick up lit or other Julie Gunnagle gear. So if you want to put that in the chat, or if somebody on your team can put that in the chat, that would be great. And then we can post it onto our Facebook. This is from Marshall Militano. He also has the comment. Well, you can read the comment later, because I want to keep this, like I said, objective, which is what we are. We are 501c3 and we do not endorse candidates. So, but Marshall is basically rooting for you, is what he says. All right. Sarah Mickelson, she is going to have the last question here. One of the most disturbing things we've seen out of the past and current leadership at Maricopa County Attorney's Office is political prosecution of protesters, painting them as gang members. How would you protect the First Amendment rights of protesters and prevent prosecution based on political belief or activity?
Whew. So, and one of the things that was so harmful and devastating, having come so close last election to taking back this office and helping reform it, is knowing that there were over 400 cases where this happened, where there were hundreds of people that were caught up in these cut and paste indictments. And there were 39 people who are facing higher level felonies for nothing more than raising their voice, which is, of course, fully protected by the First Amendment. I think we've already taken some of the key first steps, which is dismantling the First Responders Bureau, which turned into the Prosecute Protesters Bureau. But I think one of the other things that we need to do to repair harm is be transparent in how those prosecutions arose. And to this day, it has not been publicly released what exactly it looked like on the back end, because we know that this was not hatched in the mind of a single prosecutor. I expect that the DOJ investigation, and the DOJ is here in part, one of those 5 reasons, is because of the unjustified prosecutions of protesters during the 2020 election. And I expect that maybe one day we will see that. Once that information is made public, I think the other thing we need to do is we need to have a prosecutor who is committed to the core mission of this office, because if this office was centered on what the public is demanding and what the community is demanding, which is making sure that we protect people who have been victims of violence, crimes that target women, children, and our seniors, and crimes against democracy, if we were focused on those things, we wouldn't be so distracted by these unjustified prosecutions that were solely brought about for political purposes. The last, oh my gosh, there's a giant spider on my desk, y'all. Pardon me, I'm just a bit distracted. Last and not least, this is one more plug for the fact that this is an elected position. And this is an elected position because our county prosecutor wields prosecutorial discretion. And in wielding that discretion, that means prioritizing the cases that will actually keep us safe, the cases that can actually get to the root cause of harm in our communities. And these, if that was the case in the office back in 2020, none of these prosecutions would have ever gone forward or even gotten past the first step.
All right, so it is not, and thank you for your answers. Thank you for showing up today. Thank you for showing up everywhere, because I see updates happening all over social media, and you're everywhere, your team's everywhere. So thank you for stepping up. It's not easy to run for office, and it's not easy, to take time out of your busy schedule to try to serve others. So we all appreciate that. And I'm just going to give you I went ahead and put your website on the Facebook, so that they're there in the comments, folks. It's gunnagle2022.com. And Julie, if you want to close this out with why you are the best choice for this office, go right ahead and do so.
Sure. I got into this race because I was tired of seeing the collusion, the corruption, and the lies out of this office. as someone who has prosecuted politicians for stealing public funds, who has been a hellraiser on behalf of people fleeing domestic violence situations, who has been an advocate for expunging cannabis convictions, I think I uniquely get the power and the promise of the county attorney's office and what it would mean to have a lawyer in that office who shares our values. And what it would mean to me is that we would turn off the spigot when it comes to funneling our money into private prisons and not into our public schools. We could be able to reprioritize the way we look at harm in our communities so that we can actually keep our entire community safer. It would mean that we would stop being a laughingstock for perpetuating the sorts of policies that came from Andrew Thomas and the likes of Joe Arpaio. And that is what's on the line in this race. It is the race between an office that is stuck in the 1990s and the idea of having a fresh new vision of what justice looks like that encompasses not just the idea that one should be seeking justice and not merely convictions, but that we can use this office as a force and a power for good. It also means that this office is the backstop when it comes to reproductive rights, because it would be this office that would be prosecuting people with a mandatory minimum of 2 years and a max of 5 under an 1864 Confederacy era law for abortion. So now more than ever, we need someone in this office who is committed to ensuring that this office stays out of your personal life and out of your bedrooms, making sure that we are treating gun violence, addiction, and mental health issues at their root cause and as public health crises, and is going to address the historic injustices and corruption that has emerged from this office, such that you never have to question whether or not it was an instance of someone who was wealthy, who was powerful, who was well-connected, getting a special deal. If you like what you have heard tonight, I need your help, because this is going to be a very close race. This race last time was decided by a little over 1% of the voters. And out of almost 2 million people who cast a ballot in Maricopa County, 180,000 people did not vote at all in the county attorney race. That was the undervote. So this race will be determined by knocking doors, by making phone calls, by actually talking to our neighbors, by combating ballot fatigue and the fact that it is 13 notches down this local race that is nationally important. And if you like what you've heard, I'm going to need your help to close that 180,000 ballot undercount. You can learn more at gunnagle2022.com. As always, I am thankful to our host, Secular AZ, and our hostess, Jeannie Castine. Thank you so much for having me. And I know we did not get to all of your questions, but gosh, we are having coffees all over the county, and I do hope to see you at one soon.
Great. And I'm sure that they can find the events at gunnagle2022.com. For the rest of you this Friday, as many of you may have heard, an elected senator-elect stepped down from his position just last week. And there's a lot of confusion out there in the public about what that means. So if you would like to know what is going to happen in that Senate race and with the fulfillment of his term as a House member, House Member Diego Espinosa, we will be having that discussion on Friday at noon. We have programming at 6 o'clock on Wednesdays. We'll be seeing some more of our statewide candidates. So thank you to everybody for showing up. Thank you again, Julie Gunnagle, for taking time out of your very, very busy schedule. And I think that you actually do have a debate coming up. Is that right, this weekend?
That is correct. You can find me and my opponent on Sunday Square Off. This Sunday, I believe it airs at either 8 or 9 o'clock in the morning. And if that is too early for you, the PBS 1-hour debate is September 15th at 5 p.m.
Well, I hope that they can be objective in their debate. So I'm sure they can. All right. Great to see you. Best of luck to you. Thanks for everybody for showing up. And I hope you all have a great rest of your week. Take care, everybody.